Was your worst experience in a legal due diligence? What has been one of your worst experiences, or an experience that makes you cringe and you're like, was that me?
Worst.
Mm-hmm.
I don't think I've ever had like a really bad experience in a legal DD personally. Like they take long. That's what usually stressed me out. And sometimes, okay, I guess the most inconvenient thing that ever happened was just sending someone a request list and they just ignore it. Or they send it back and they've responded to maybe 2 things. And so you spent weeks potentially putting together the most structured, well thought out request list because you want them to now populate a data room and number it accordingly based on what you've put in the request list. And then they just ignore it. Or they just fill in 1 or 2 things and then they send it back to you. And I'm like, so what's the purpose of this whole thing? Maybe me on a more positive note, the most enlightening or interesting experience I ever had in a DD was we were doing a DD on a school. And so the beginning of the due diligence, we were representing the acquirer. We went with the acquirer's team to the school and we sat with like the principal, like the headmistress. Yeah. And we all sat together. This was a kindergarten and primary school. So that we understand, okay, that what we talked about in episode 1, lay the ground rules. What are we going to be looking for? What do we need? What's the purpose of this due diligence? All of that.
Yep.
What was really interesting was that she took us literally to a classroom, which I thought was really smart. Yeah.
Oh, okay.
It was smart because she wants to show us, why we're doing this and the importance of the deal, right? Yeah. So you're coming to buy my business. This is my business. This is what I do on a day-to-day.
Okay.
She took us literally to, I think, like the youngest class. And there were no students there. The students were in other...
Made you sit on those tiny...
We sat on these tiny tables. Everyone had their own little table. We all sat. And she walked in and we're like, hi, Mrs. So-and-so. So we felt like school kids again, but it was such a cool experience just being there, being in a school.
Were you even able to sit well? Your knees were above your head,
No, it was really awesome. Once we sat, the desks were like basically up to here. But anyway, we sat and she ran us through things and very respectful, amazing lady. So the deal went through. It's
an interesting one.
But it was a fascinating way to start the due diligence process. Yeah. But you seem to have a horror story. So what happened?
No, it's actually not really a horror story, but I think I will not forget my first due diligence that I did, legal due diligence.
Yeah, okay.
So I was brought into a transaction, that another associate was working on, but I don't know, things were not exactly working. So I came in to this transaction and I worked on that DD report. I reviewed the documents, literally prepared it the best way I knew how. Sent it to a senior associate. They looked at it. They were like, looks good. Then it went to the partner. Well, we were called for a meeting.
Oh, wow. That's bad.
The 2 of us, and you went down disconstructing the DD report from the beginning. I have never felt like my work was trashed like that moment. Because, and the partner made so much sense. I could see what he's talking about.
Yeah.
The thing is, I had really done my best. Really, I just applied my best the way I knew how.
It was your first time?
Yeah, it was my first DD. Yeah, but I just remembered that moment, us sitting in the boardroom with the DD report in display, and the more we progressed, the more it turned red. The tracking, the DD report turning red and red with everywhere. But I learned very crucial lessons then. So that was my first.
The lessons that we learn along the way. It's always a very scary thought when a partner calls you in and you look at the document you prepared and it's all red.
Yeah.
It's red, please fix. What is this question mark? That's when you just see a question mark. It's like, man, I don't even know what they're asking about here.
And some of things look even logical. You're like, how could I miss that? Yeah, anyway. But we all learn and grow, so.
Welcome back to the Full Scale Podcast. This is episode 12. I am your co-host, Adrian Twatwa. I'm joined by my co-host, Timothy Mukiti. Yeah. How are you doing today, Tim?
Doing well, thank you.
Yeah?
Yeah.
Welcome back. Another episode, another week. Thank you for tuning in, wherever you're watching from or listening from. We really appreciate you. Thank you for being part of our audience. Today's episode is a deep dive on legal due diligence. So hopefully you watched episode 11, where we generally covered what's a due diligence, what's involved in a due diligence, what types of DDs are out there, the process that's involved, the motivation and why people are doing a due diligence, all of that. So today we're now doing part 2, where we're going to focus specifically on a legal due diligence. So looking at a due diligence through the lens of, or through a legal lens, which is what, a lot of what Tim and I do, looking at it from a lawyer's perspective specifically. So we think a lot of the value that we can provide as co-hosts on this podcast and as lawyers is for our viewers to understand what we as lawyers would be looking at when we undertake a legal due diligence. So today we're going to be walking through some of that. What are the things that you expect to see in a legal due diligence? What are the questions that you'll be asked? What information are people looking for from your startup potentially? And what comes out of that? How do we then mitigate the issues that we've found in a legal due diligence so that hopefully your deal goes through, seamlessly and without any issues? So Tim, maybe you can kick us off by explaining what is a legal due diligence. And I know we covered a bit of this in episode 11, but maybe you can just flesh that out for us before we get started.
Indeed. Happy to. But perhaps before even getting to that, I would like to recommend as a build-up to what you've mentioned, recommend to our audience, we suggest that you, and we recommend that you watch episode 11, where we discussed broadly what a due diligence is and what to expect from a due diligence, because some of those items would apply to a legal due diligence, including the due diligence process and how it looks like. So a legal due diligence is basically the process of reviewing, investigating, or undertaking an in-depth review of the legal aspects of the business, legal compliance levels, the legal aspects, and basically the legal elements of a particular business or something. It could not even be a business, it could be an asset. But generally, that's what a due diligence, a legal due diligence would be in a nutshell. And it includes examining things like corporate governance of the particular business, the corporate governance documents, the contracts the business has gotten into or the entity has gotten into, employment agreements, intellectual property. And when we say employment agreements, we also mean there's also employment policies or HR policies, intellectual property, litigation history, or any pending or threatened litigation and the risks accompanying the litigation, as well as regulatory compliance. So those are some of the items that will be considered in a legal due diligence. Ideally, it helps, investors or parties participating in a transaction relating to this entity that is being reviewed to identify the potential risks that could affect the viability or the value of the investment. And also ensures that the particular startup or business is compliant with relevant laws. When we say potential risks, things like title, ownership of business or ownership of property are legal questions.
Okay.
So if those are not properly in place, your title to either to the business or ownership to a particular asset is not properly in place, then any underlying transaction or any transaction that relates to that particular underlying asset is potentially impeachable. It's an impeachable transaction. And by impeachable, I mean, it may not stand the test of time if there's a litigation or there's a dispute as to the ownership. So you need to verify some of these things. Things like corporate governance, you would like to verify who makes decisions, whether they're actually validly in place, and whether they make decisions in accordance with the prevailing regulatory framework and the laws that affect the particular business. So that by and large would be what a legal due diligence would be. I think it would even be a good place for us, although we touched a bit on it in the previous episode 11, to explain some of the why you would be undertaking legal due diligence. In the previous episode, we discussed broadly why you would undertake due diligence, and including different types of due diligence. But I think it's important to just point out some of the reasons you might be undertaking legal due diligence. One of them is for purposes of identifying compliance concerns for an entity you want to acquire.
Okay.
If you're planning to invest in a business. The second one could be basically for purposes of maybe regulatory compliance. Maybe you need to undertake a process like we mentioned in a previous episode of you want to list securities and you need to develop an information memorandum which you're going to share with potential members of the public who are going to acquire shares in this business, or maybe you're floating a corporate bond. You would need to undertake a legal due diligence so that you report to them the status, including the corporate governance, compliance levels, regulatory licenses and approvals that the business has. And then you share that with them. Now, this affects the manner in which you're going to be reporting, and we will touch a bit on the reporting for due diligence. But I thought we can point that out for purposes of our audience, just understanding, some of the purposes that you may undertake a due diligence. There is also a vendor due diligence. Again, we mentioned this, which is you undertake a DD on a business for purposes of selling it. So you'll provide the findings to the potential buyers, and then they can do a further DD if they want, or they can confirm a few things here and there. Yeah. Or you can do it for purposes of providing insurance,
Yes.
Yeah, for the business.
Yeah.
So,
or your own like internal health check,
Exactly.
etc. But
And
you might just want to know where do we stand in terms of legal compliance.
Yeah.
Okay.
Yes.
So maybe I'll go through then
Yeah.
what exactly is covered in a legal due diligence. So it's going to be a bit dense and a bit heavy. So just bear with us. I'm not going to go so technical, but I want to give folks a real, peek behind the curtain as to what exactly we look for when we're doing a legal due diligence. So I even brought a legal DD checklist with me.
Oh, nice.
Sure, Tim's been wondering what's this heavy document Adrian's lugging around.
Serious commitment there.
Yeah, so this is proprietary info, guys. Don't zoom in so much.
Yeah.
Trying to see what's in here.
Yeah.
But I'll explain broadly what's covered in a legal due diligence checklist, because that's the document that we would prepare initially. So I guess in terms of the context, we're assuming for purposes of this legal due diligence that we're talking about, Tim and I have been approached by a client. This client is a huge, let's say, private equity fund. Private equity fund has identified some startup. Let's say the startup is doing a Series E raise, and now this PE fund wants to potentially invest, but they don't know what's happening in the business. They want us to do a legal due diligence. They've also hired separately finance experts to do a financial due diligence. Perhaps they've also hired someone to do maybe an ESG or some other type of very specific due diligence. But as for us, because we're lawyers, they've come to us and said, we want you to do the legal due diligence on this business. So first, and we talked about some of these steps in the previous episode, so check those out if you missed them. But ideally, we would then be put in touch with the target company, have an initial meeting. Maybe we go sit around in a kindergarten, wherever it is. And we lay the groundwork for what it is that we're trying to accomplish, what we need from them, and what we're going to be asking them for, and just how the process is going to work. We would then prepare a due diligence request list, or a DD checklist. That's what we as the lawyers are going to send to the company, to the startup, and say, please provide this information. Ideally, preferably in a well-organized data room where you have numbered everything the same way that we have numbered it in this document. So that way we can check one-to-one. We check item number 1. We look at it in the data room, item number 1. Check number 2, number 3, and so on and so forth. Tim's already previewed some of the items that we'll be looking at, but just for completeness, we would start generally, and also before we begin, this is not legal advice, a big reminder. I know this is very legal and we're talking about some of the ins and outs, but everything varies, everything depends. Your situation is very different from any other situation that's out there. You need specific, precise legal advice that is tailored to your business and what you're doing.
Exactly.
So not legal advice, talk to your legal advisors, seek professional legal advice. Okay. So we start with the corporate structure. So this involves reviewing the company's incorporation documents. So what are the documents that essentially gave life to this entity? So your certificate of incorporation, your articles of incorporation, your shareholders agreement, your maybe constitution internally, or your bylaws. Depending on your jurisdiction, they might have different names. Any amendments to those documents. we've talked about all of this in the agreements episode in season 1. So you should know what these generally mean, but we need to see all those documents to begin with. And it's very important because we want to know, first of all, you're telling us to invest in your company. Is it even a company? Maybe it's a partnership. Maybe it's structured differently. What are the rules internally that govern this entity? How do shareholders make decisions? How do I know that if I buy my shares from you, another shareholder isn't going to come and say, actually, the shareholders agreement says this person can't sell to you. They need to first sell to me as the existing shareholder. Exactly. So there are all sorts of little tripwires and things that you might find in there that you need to raise in the initial report. So that's why we need all that information. In addition, you'll usually have a table that will provide and say, fill this table out. And that table is sort of like a structure table, right? So who are your shareholders? Who are your directors? What's your registered address? How often do you hold board meetings and shareholder meetings? How many shares are there in the company, right? Paid up shares versus authorized shares or issued shares. I know this document's giving Tim flashbacks of bad experiences in previous DDs.
Yeah.
So who are your directors? Who's the company secretary? Basically a general corporate information summary so that we can, it's a snapshot of what's going on. Your cap table will probably also feature there. So just a snapshot, if someone were to take a photo and just have all the information they need generally about how your company is structured, that we also need that. So that forms the basis of our understanding of who owns this company, who are the directors, who are the key people in charge. So then we know maybe Tim is the CEO, founder, director, lead employee, he's everything. Then he's a key person in this. If he falls away or something happens to him, we're really, it's not a good situation for us as investors. So maybe now we want to look into maybe some key person insurance or something.
Yes.
So that's sort of the corporate structure. Anything else you want to do on corporate structure before I move to contracts and agreements?
No, I think you have covered it pretty well. Yeah.
Great. So after we've looked at, now this is the first set of information that we need. So line item number 1, we need all this corporate information about your company. Line item 2, we now want contracts and agreements. So whatever your business is, you probably have certain contracts that underpin the way that you do business, that are the most important thing for how you do your business. So if you are a beverage supply startup, you most likely have distributor agreements because someone has to distribute the beverages that you're putting out there.
Exactly.
Or you have contracts with your key customers. Like, these are my key customers. They're the ones who pay most of my bills. So I want to look at those contracts and make sure that I understand who are the contracts that you have, who are the people that you're working with, what are your recurring revenue streams. I mean, I'll see them in the finances, but I need to also see the agreements that you have with these people so I understand what the terms are.
Exactly.
We need to understand things like change of control. Change of control is a huge one.
That's an important one, especially if the DD is related to a transaction. If either it's an acquisition or it's an exit. What does that mean? If and when we say change of control,
you want to tell us what change of control
exactly
means?
It means that if there's a change in the parties who control the business, either through direct change, either you acquire more shareholding and you control the business, or you have particular rights that allow you to make some decisions that are equivalent to gaining control in the business, whether this contract can still survive that change of control. Some contracts terminate automatically if there's a change of control in the business. So you have to review this particular contracts and agreements that are in the business. So assuming you're acquiring a business that is in, just to use your example, in the beverage business, and you want to acquire it and continue with their business, but all their distributor agreements provide that they will terminate the moment there's a change of control. Literally, from the day you acquire the business, you have no way to distribute the product because you will need to renegotiate new contracts with distributors. So you don't want that kind of a disruption. And if there is likelihood for such disruption, you start to plan ahead of it, and maybe perhaps get into novate the contract or get into other contracts.
There you go with your big words again.
Well,
novate,
which is basically you're amending the contracts. You're changing the terms of the contract such that maybe that clause falls off. There's no risk for the business. So it's a business continuity issue, right? I'm trying to buy this business from you because I see value in it and I like the way it's currently running, or I want to improve on it. If I buy that company and it can't continue the way it's been running, then that's an issue for me. So I need to make sure that once I step into your shoes as a buyer, or I come alongside you as a partner on the cap table,
we are able to continue the business, despite the fact that, or notwithstanding the fact that I'm now a new partner in the business. So it may require going and renegotiating those contracts. It might need to renew them or sign new contracts, etc. But it's a big one. Change of control is a huge, huge issue. So, big customer, clients, supplier contracts, knowing who those customers are and suppliers, which I think also goes to the heart of why we said you need confidentiality before you start sharing information in a due diligence process.
Yeah.
Because you can imagine your biggest competitor wants to acquire you, and then you've shared your list of all your suppliers, all your distributors, everyone who does everything for you, all the people you're contracted with, and the terms. They could then take that and say, you know what? Let's go offer better terms to all of these people and take this person's business instead of buying the company. So you need confidentiality and other restrictive covenants to make sure that they don't use that information in a way that hurts your company.
Yeah.
So those are commercial contracts and agreements. So basically everything that could also include lease agreements if the property that you're on is sort of where you're doing most of your business. Maybe it's a warehouse. You need to look at the lease of that. You will look at that under real estate, but also within the commercial contracts, it would be important in that case. So that's corporate structuring, that's contracts and agreements. We then also look at employment and labor. So here we're examining your employment contracts, your employee handbook. Usually you should have, this is the handbook of how employees should operate and the policies and the ways that people should conduct themselves within this organization or this startup. So we would want to look at that and make sure that that handbook, the contracts, the policies, all of them are standard. They're good in that they clearly spell out what people are supposed to do. They're transparent, they're clear, but also that they are in line with the law. So usually in any given jurisdiction, there's some sort of employment law or labor law. You need to make sure that all the employment contracts, the policies, they're all matching or in line or go above and beyond what the law asks you to do or requires you to do. That's really the HR piece. I don't think it's a complicated thing when you do it, but generally understanding it, I think, is pretty straightforward because most people are in employment or they understand how employment usually works. So understanding that your employee contract would be the subject of the due diligence, I think that's a pretty clear thing for people to understand. So that's employment and labor. We then go to IP. IP is a huge one, and
we mean intellectual property.
But viewers and listeners of the Full Scale podcast already knew that.
Sure. Yeah.
So intellectual property is a big one, specifically because we've spoken a lot in season 1 about how the companies that have the highest sort of ceiling when it comes to making returns and being able to scale, a lot of the times they're tech-enabled companies.
Exactly.
So either their tech is their whole thing, or they're using tech to do the thing that they typically do. Yeah. So because technology allows you to scale, it allows you to reach people all over the world and really distribute your product or your service worldwide. A lot of what underpins that technology is intellectual property. Someone has sat down and thought of a way to distribute this service, this fitness product, this agricultural service, this fintech solution or payment service. There's a technology that's been built specifically for that thing. The way that you've built that and how it does what it does is your proprietary knowledge. You're gaining commercial value from it, and hopefully you've protected it in the form of intellectual property rights that you've registered locally or internationally or regionally or wherever sort of you lie, and how that's done, which you will have spoken to your legal advisor and they'll have told you how to do that. Yep. So your intellectual property will be a big component usually in the due diligence, the legal due diligence review, because now we'll want to verify, okay, this is the intellectual property that you're using to do X. Do you own this intellectual property, or are you leasing it from someone, or who invented it? You want to make sure that if it's an employee that came up with this way of doing things internally, this patent or this trademark, we don't want a situation where that employee, after we've made the purchase of the company, this employee leaves and says, I own this intellectual property in my personal capacity. I personally own it. It's not the intellectual property of the company. And so I'm taking it to your competitor. I'm taking it with me to build my own product. So I want to make sure that it's owned by the company. There's no one else out there.
If it's not owned by the company, there is a system which automatically assigned any intellectual property rights that are developed by either employees or founders in the course of the business
Yep.
automatically assigned to the business.
Correct.
Or have a right for the business to get an assignment of that intellectual property.
So you see how all these things come sort of work together, because we're looking at the intellectual property to make sure that once it's developed by an employee, it is actually owned by the company and not the employee. But the only way you'll know that is if you look at the employment contract, typically, because the employment contract is where it will say that. So you're looking at the employment contracts for those things, for all the HR stuff we talked about, but you're also looking at it for this IP component.
Exactly.
And then you look at the IP component, it also dovetails with the employment stuff. So it all sort of works together.
Mm-hmm.
And that's why a lot of the times when you're doing a due diligence, a legal due diligence, you need a team of lawyers or a lawyer that has a good view of all of these different aspects. Because if you approach a lawyer to do a legal due diligence and they're really smart on the corporate angle and maybe the HR angle, they could miss some of the intellectual property stuff that you need to know about. Or they could get the intellectual property stuff, but then they miss something on the corporate shareholding. And it turns out there's another shareholder that you didn't know about.
Yeah.
And now you're sitting across from them at the shareholders meeting wondering, who are you? Like, how did you get here?
Yeah, or they're going to court to stop the transaction from proceeding.
Exactly.
And while you thought you should be closing, you know?
Exactly.
Yeah.
So that's the intellectual property right. Making sure that the company owns and can protect its intellectual property and can use it in perpetuity, right? Even after the seller has left, even after the employees have left, everyone who is connected with the company, even if they were to all leave today, the intellectual property still resides and is owned by the company, and the company can continue to do what it's been doing all along, and is able to do that legally without anyone coming in and filing a lawsuit. We then move on to regulatory compliance. So this is also, maybe you can think of it as regulatory compliance, permitting, licenses, authorizations. I sort of like to lump those together, but you can also put those in completely separate buckets. But generally, the overarching thing here is you want to ensure that the company complies with sort of industry-specific regulations and standards, and also jurisdiction-specific regulatory or licensing and permitting requirements. So let's assume Tim and I, we're building our fitness app here in Nairobi. And then it turns out there's a Fitness App Act that comes out tomorrow, which requires anyone who's making a fitness app to register and be licensed with the government of Kenya's fitness app division, right? Mm-hmm. If that happens tomorrow, then we need to make sure that we're in compliance with that act. Exactly. We need to go through the regulatory and licensing process and make sure that we're in line with that regulation. Mm-hmm. So if someone comes to buy our fitness app, the very first thing they'll ask about is, well, you know that there's this law in Kenya. Are you in compliance with it? Mm-hmm. So it usually comes up a lot in very regulated industries. So if you're investing or purchasing a hospital or a school or a bank, things like that are usually very heavily regulated. So that before you can even consider an investment in them, the entity needs to have those licenses. But even you as a potential shareholder, there may be things that you need to qualify. There might be some proper and fitness tests for you. Even football clubs these days. See, if I go try to buy Arsenal Football Club today, I may not have the money for it, but they might check and say this guy is not fit and proper because he's for whatever reason, right?
Yes.
So that's something else that you need to consider. So making sure that any permits, licenses, so you might have county or district or state level or federal level or county level licenses or approvals that you need to get in order to do the business that you're doing. Typically in any given jurisdiction, there's at least a business permit that you need to do to run a business. So having that and making sure that it's valid, it's not expired. Those are the types of things that we're going to be looking at when we look at your authorizations and regulatory compliance. Anything there that you wanted to add before I move on to, let's say, financing arrangements?
Perhaps what I can add is that, regulatory compliance is usually quite big because it comes with potentials for significant penalties and sanctions for not complying with the respective regulatory requirements. Yeah. Some of them could be so punitive to the extent that the business may not continue after, for example, acquisition. For example, if you're making an investment or you're acquiring a business that is in the banking sector, you need to understand what happens, what are the regulatory compliance you need to do with maybe, for example, the Central Bank of Kenya. What are the requirements? Because it could be possible if you go through the transaction in this particular manner, then the license is revoked. So you do not have you've acquired a bank that is not there
That doesn't
anymore.
have a banking
The moment you
license.
lose the license, or it could be that some of the sanctions you could be reprimanded by the regulator, and that brings bad publicity, and you run the risk of even not getting future approvals to do that kind of business. So so part of what you're considering, of course, is the levels of compliance, but again, you're also considering what are the risks associated, what are the potential exposures, and it even helps you know how you're going to maneuver the particular transaction. Because some licenses are actually not transferable. So exactly. So you need to understand how you're going to do the transaction. So you may actually be required to make an application for a new license. So you could do the transaction conditional on getting a new license. So,
kind of similar to a change of control ish.
Exactly, almost the same concern that you would have on a change of control. So some licenses, permits may not be transferable, and that could be a concern.
Okay.
Yeah.
Next one I'll talk about is funding arrangements. So we've looked at your company structure, your contracts, your employees, your intellectual property, regulatory compliance, all of that. Next, we're looking at your funding arrangements. So what are funding arrangements? So I like to think of this as ways that you're getting money that's not necessarily your revenue, right? So let's say you're taking out loans. I think loans would probably be the biggest one. If you are a company that takes out a lot of loans, we need to look at each and every one of those loans before we step into your shoes and take over the company. We want to know how, what's the tenure of these loans? Are they being paid down? Are they in default? What's going on there? If you have a credit facility that's ongoing, what's the balance on that? How often do you get loans dispersed? How are you paying those down? Because it is a crucial component, right? Because if there are a lot of loans in the company, it's not necessarily bad to have loans, but how those loans are being managed and handled on a day-to-day basis, that's something that's going to be crucial.
Or the rights the loans have, because you could have loans that accelerate the moment you change control.
Yeah.
So if you owe $1 million, the loan agreement could have a clause that requires if there is any change of control, this amount becomes due immediately.
Correct.
It has to be paid. So you acquire a business, and the next thing is you see a bill of $1 million. You know? So you have to review maybe what could be related to this funding arrangements here.
True. Yeah. Or the loan could use an asset of the company as collateral or a security. So, or there might be a charge on something or sort of within the company based on a loan that was given out. So the issue there is understanding, are there loans? What are they secured by? What's outstanding? Just so you have a general sense. And again, so you can make an informed decision. And what are the terms of each and every one of those loans? So including letters of credit, bank guarantees, other facilities, letters of support. You could also have grants and allowances and things of that nature that are not necessarily credit, but there are also other ways that you've received funding. And so
grants usually come with conditions usually.
Exactly.
So you need to understand what conditions you need to satisfy for this particular grant.
Exactly.
Yeah, and I think another one to point out is whether the loans or the fund, if it's the funding is done through loans, whether they have a right to convert.
Yeah.
So you need
into
to
shares.
Exactly, into shares. Oh yes, whether they have a right to convert into shares or equity in the business. So if you're acquiring a business and your goal is acquire control, or perhaps you could think that you're going to acquire it 100%, then you have this facility that has a right to convert. So the moment you do 100%, they come and they say, we need 20% shareholding because you have a right to convert. Those are some of the other things you might be looking around the funding arrangements. And the funding arrangement is literally a legal review, because especially of the agreement bit of it. These are commercial agreements, or these are funding agreements.
Correct.
That have rights and obligations that are likely to affect how the business operates and runs.
Very true.
Yeah.
One other thing is, if I'm trying to purchase just an asset as opposed to an entire company, I'll want to know if there's any charge or mortgage or obligation attached to that asset, right? So if I want to come and buy Tim's car, and Tim's like, great, here, kick the tires, check the mileage, check the engine, whatever, and then give me the money. If Tim actually took out a loan and the security for that loan is the car, even if if it's well registered and perfected and everything is in order, if Tim sells that car to me today, I might be driving it around for a day or two and I'm very happy. But the moment Tim defaults on that loan, someone's going to come collect the car from me and say, hey, actually, this car was used as a security or as collateral for this loan. So actually, I'm the one who now, the lender is the one who now actually has the legal ownership to that car. So if you're doing a legal due diligence on an asset specifically, also, you want to understand if there are any sort of charges or any other obligations that attach to that asset, so that if you do take it on, you know that you have proper title to it. That's financing arrangements or funding arrangements. The other one that's really big is litigation and disputes. So I think this one will be pretty straightforward. You want to acquire a company, but the company is tied up in a long-running litigation that's been ongoing for 10 years. And so you're wondering, when's this lawsuit going to end? When is this dispute going to settle? Like, what's going to happen? And what are the ramifications, right? The lawsuit might involve damages. So the court might say the company actually owes $1 million. If the company is worth $1 million and you're planning to purchase it, but there's a lawsuit outstanding for that very same value, it might not be worth it to do the deal. So making sure that you understand, are there lawsuits past, pending, or potential, right? So it's sometimes hard to understand if there's a potential lawsuit, but this is why we go through this process, right? We need to ask the questions clearly in the checklist. Like, do you know or have reason to suspect that there's a potential lawsuit? Or so it becomes very legal in that sense. You have to craft those questions very carefully so that you make sure you get the right, all the information that's out there. So understanding the litigation aspect and if there are any risks and how those could impact the business, I think that's huge. Real estate is the other one. And I think we've sort of touched on this a bit already as we've been going through this. But crucially, the title to whatever real estate is being used for this company. So we have our fitness app. We are housing it, all the hardware and everything that we use in a specific building. Yeah. Do we own that building, or are we leasing it, or what's the situation there, or are we just squatting? Right. Yeah. That could be a big issue if we don't even own where we're doing what we don't have any legal right to be where we are.
We don't have any property rights, either by lease or ownership.
Yes. Yeah. So that's a big one, because you want to understand and make sure that you understand where the operations are happening. Usually, especially in the real estate portion, we'll ask for a list of all the properties. So everything that's owned by, so this also goes into assets, but all the properties that are owned by the company, but also all the places where the business is being done. So for the example, for the school, we said, where are all the different branches of this school? And for all of those branches, who owns the lease or who owns the title? So it's quite a process. You need to go to like the lands registry in Kenya or whichever jurisdiction you're in. You need to go and trace the title of the ownership of that land to make sure that it's actually real. You sometimes find forgeries and all sorts of other nefarious things. So you need to make sure that everything is in order when it comes to the real estate portion. And I think I'll just end on, perhaps, do you want to touch on tax?
Well, yeah, some of the areas that could be considered include tax issues regarding the business. This is basically considering, especially whether the business has been in compliance with the existing tax laws, in terms of its tax obligations, paying taxes as they are due, paying particular taxes that are required, making the returns that are required and making them in a timely manner, identifying whether there is a potential dispute or an existing dispute with the tax regulator, tax revenue authority, and whether if there is such a dispute, what the status of the dispute is. And basically just now identifying if there are any concerns around the tax. Another one could be ESG concerns, environmental, social, and governance. And you're basically looking at, on the environment aspects, whether the business has licenses that it requires. Maybe some of the licenses could include effluent discharge licenses. If it's working in an environment where it's doing a bit of noise pollution, is it within the regulated levels? They have licenses for that. Social, how exactly is it behaving as a citizen of the society? What impact is it making? Is it a sustainable business? Is it being a good citizen? And then, of course, governance structures, which could go back to dovetail into what we discussed initially about corporate governance. These are considerations you have about, is it even complying with a particular governance? Because there's some governance requirements that are specific to a business when it operates within a particular maybe industry. Because maybe if you're in the fintech or you're in the financial services sector, the central bank may prescribe particular governance compliance requirements. If you're in this, if the business is listed at a securities exchange, there are some governance compliance requirements. So you also have take those into consideration as part of the legal due diligence
For sure.
review. Yeah.
The only other one I'd add is, and this is also one that's growing in importance as we go along day to day, is data protection.
Yes.
That might be a big one too, because increasingly we're seeing countries coming up with their own data protection laws or data protection acts. And so making sure that the way that that company or that startup, to the extent it's receiving customer information or identifying data of individuals, we need to make sure that we understand how that's being handled. What are the policies? What are the systems in place to make sure that all of that is being handled in compliance with the law? Because again, you could run afoul of the law, and there could be penalties for that you're not foreseeing. Then you become an owner of the company, and the day two, you find that there's this data protection issue, and you're maybe receiving a lawsuit or a sanction. So that's a big one also to look out for. So
there are significant exposures. Yes.
Yeah. So I think those are, there are many areas you could go into. You could do like an IT specific one, or like the legal essence of like the IT systems, or there's so much you could do within even a legal due diligence. But we've tried to give you the general scope of what we typically look for. But even within the ones we've discussed, there's a lot more that you need to drill down in terms of each of those. So even within corporate structuring, has there been a reorganization, or what happened in the past? A lot of this information you need to look, it's all backwards looking, but you need to figure out what's the time frame from which we're looking at. So if we're asking about litigation and disputes, we might want everything from the past 10, 20 years. If it's a tax issue, we might want to do it only maybe the past 4 years, if that's the look back period for tax authorities in that country, right? If in that country the tax authorities can only come after you, let's say 4 or 5 years after you've missed a tax payment, then we're not really too concerned about 6-10 years before, prior to we came into this company, right? So it depends on what you're looking for. It depends on the type of company. It depends on the risks associated with its industry. It depends on the people running that company and what they're doing. So the big highlight here is it all depends, it all varies, but these are general things that we look for. And again, you need to talk to your specific legal advisors in the situation that you're in to give you the specific advice you need for the type of due diligence, the legal due diligence that you need for your business based on the transaction that you're trying to undertake.
Thank you for covering that. So perhaps you could go into what potential areas that a DD would be expected to flag.
Okay.
So and this is basically on the reporting side. You've undertaken your DD. You're preparing the report. How exactly are you supposed to cover, and what specific issues would you be expected to cover? So of course, one of what you would be required to do is, first of all, clearly identify what the issue is.
Okay.
Don't just say the company has not filed returns. What returns?
The tax returns, company returns,
annual company returns. Is it returns required by the insurance regulatory authority? Say the company has not filed annual returns for this particular year. Okay, identify what the issue is, or maybe, it could be that it has filed, but you haven't seen them. You could see from our review, we did not see. So that is the first thing. You clearly identify and explain what the issue is.
Okay, and
then the second one is provide why that is an issue. Okay, fine, it hasn't filed annual returns. Why is that an issue? So you could go to the next level and say the Companies Act requires that a company should file returns within this particular time, so it's a requirement under law. And then provide what are the consequences, clearly provide what are the consequences for not complying with that.
And I think that's key, because most clients or most people won't. They'll understand that, okay, it's a requirement under the law. I get it, but why is that important? What's the consequence if we don't follow the law?
Will it hurt me? And if it hurts me, how painful is that? Because like we mentioned in episode 11, the goal for and we have also rehashed it here. The goal for due diligence is for purposes of informing decisions. providing such comprehensive review and analysis to the point of making informed decisions, either to progress with a transaction or how to progress with it, if we choose to progress or even drop it. So if you're not providing adequately what the consequences, then you're not enabling the decision maker to make an informed decision. It could be the consequence is that you'll get a reprimand letter. I mean, and they're not worried about a reprimand.
Or the consequences might only affect the people who are leaving the business.
Exactly. So it's not a concern.
Exactly.
And then the fourth element now is clearly provide ways to mitigate the issue.
Okay.
And by ways to mitigate the issue, you're saying, okay, so this is what we recommend. The company should proceed and file its annual returns within this particular time. Or if there are penalties to be paid, this should be paid. If you need warranties for the transaction, then you can provide those. Yeah. So now on that particular point on identifying ways to mitigate issues or the issues that you've found, in a DD report, in a DD review, as you've made reporting, perhaps you could take us through, a brief discussion of, how you'd progress with the findings that you've made as a way of mitigating the issues and resolving the concerns that you found in the legal due diligence that you have undertaken.
Got you. And thanks for that. I think that was a good breakdown of how to flag issues well. And that's probably all the learnings from that first day with that partner. So thanks for reminding us on those. Okay, so how are issues that are raised in a DD report then handled or mitigating, or how are those findings used? So I'll try to go through this pretty quickly. So we're talking about this within the context of a deal. So the deal is someone wants to, Tim and I are trying to purchase a company. So we've done the legal due diligence on the company. We started out by entering into a term sheet with the owners of the company. We then did the DD. Now we will proceed to sign an actual acquisition agreement that says we are hereby acquiring this company. After the signing, there will be at some point the closing, which we explained previously. That's now when the actual deal is done. It's actually fully finalized. Usually money is exchanged. That's when we now own the shares and we become shareholders, etc. Between signing and closing, that's when the conditions precedent gets satisfied. We also talked about that. Conditions precedent being conditions that you need to satisfy after signing, but before the deal is closed. So how you deal with the issues that come out of the DD report, they can fall sort of anywhere in that range, right? So let's assume if the company had already done an internal check and identified some of these issues, perhaps they would have resolved them even before we signed a term sheet because they already knew them and they resolved them way back when. Other times we might have issues that come up and we as the purchasers, we're so uncomfortable with these issues that we say before we even sign the acquisition agreement, we need you to figure this out. Like we've signed the term sheet, we've done the due diligence, we've found these issues. But before we sign the acquisition agreement, we need you as the company to go fix these issues. Or they're so small or easy to fix that you should go deal with them anyway before we sign. So there is a potential that we could deal with those issues before signing. For example, there may be some internal shareholding that needs to be cleaned up. The cap table, we see this a lot where the cap table is a mess. There are so many different people there. We need you to reorganize your company before we can even consider becoming shareholders in this company. Things like that. It could be dealt with before signing, or it could come up as a condition precedent, which is after signing but before closing. So we sign, but we're signing this deal on the condition that before we close, you need to do XYZ to fix the issues that we have identified. It may be an issue that's ongoing, or it may be the fact that we've discovered it's a regulated business and there's a license that the regulator needs to provide before we can acquire this business. We talked about the Competition Authority of Kenya and other competition authorities or antitrust bodies that need to approve of these types of transactions. So that's another thing we do as a condition precedent. So you could fix these issues before signing, between signing and closing. Sometimes you could deal with them after closing if they're not so significant and they just need to be dealt with at some point, in which case we term those conditions subsequent. So they're subsequent conditions that need to be satisfied subsequent to closing. So after we close the deal, make sure you go back and do this thing. And I guess it's a bit hard sometimes to hold people accountable for conditions subsequent because the deal's already done, right? So what are the repercussions for me as a seller if I've already sold all my shares and I've walked away and I don't do this thing that I said I'd do as a condition subsequent.
Well, there are ways. There are
Do you want to
smart
talk
ways
through some ways?
Yeah, there are smart ways to get the parties to deal with conditions subsequent. That is basically conditions that you're requires to fulfill after the transaction has been completed.
Correct.
There is a closing, and some of them could do with maybe an escrow arrangement.
Correct.
The money is paid out, but it's not paid completely.
Yes.
Or it's put in an escrow, so you'll only access it if the conditions are satisfied.
Exactly.
You could also have a way of recovering a bit of the purchase price,
like a clawback.
So, exactly. You can be able to claw back part of the purchase price if these conditions are not satisfied.
Yep.
But usually the conditions subsequent are left mostly for issues that are a little bit innocuous. The risk level is just
pretty low.
You're happy. Okay, these ones may not be completed at this stage. We want to proceed with the deal for commercial reasons, and then we're saying, okay, fine, we're proceeding with the decision with the deal, but please make sure you complete you just satisfy this. Yeah, and you've had terms such as a 100-day plan, where you set out particular issues that must be done within 100 days of the transaction. So mostly things that you're not happy with yet, but which are not so big as to stop you from proceeding. It takes us back to the discussion that a due diligence should inform decision making. So you know the risks, you know how to mitigate them, and then you proceed to make a decision. We will go with the transaction anyway, provided these are satisfied at this particular stage.
Exactly, and you can act accordingly. Exactly. Another way that you could deal with those is perhaps if there's an earn-out.
Yes.
An earn-out being we are buying this company, Tim and I are buying this company from, say, Steve. Steve is the owner, CEO, founder, all that. We're buying it from him. But after we buy the company, we want him to stay on as a manager in the company for like a year, for example. And if he stays on for a year and accomplishes XYZ things, then he'll get a bonus or he'll get whatever other financial reward.
Yeah.
So it incentivizes that person to stay on, give us business continuity. Nothing's changed. It's just new ownership, but things are still moving forward. But if they're conditions subsequent, we could bake them into the earn-out condition. Say, if you don't do XYZ after we close the deal, you won't get this other bonus or payout.
Exactly.
So you could deal with these issues before signing, after signing, as a CP. You could also deal with them in the document itself, in the acquisition agreement, typically in the form of warranties or indemnities.
But maybe you can also mention something about, maybe now as a mitigation of issues that you have identified in the transaction, affecting the price. I
guess that's the last one, right? So you could account for all of these issues in the documentation, in the as conditions precedent, as conditions subsequent, as reps, warranties, indemnities, all these things that we've talked about. But I think the most basic version of how you account for that is, I've found that there's a hole in your business worth $500,000. I'm just going to deduct $500,000 from the purchase price, right? Or somehow, or in any other way, you adjust the price of the deal to address or compensate for this issue. So that's, I guess, the last resort, hopefully, because by the time you get to this point, you don't want to start changing the price. There's been so much calculus that's gone into figuring out what the price of the deal is. So you don't, as a seller especially, you don't want them to start changing the price on you at the last minute. But if there's an issue big enough, you may end up having the price reduced, or the pricing, the payment of the price of the amount could be then structured in a way that maybe it's put in escrow until you resolve an issue or something of that sort, where you're now getting the payment delayed because this issue still needs to get resolved.
Exactly.
Okay. And maybe just in closing, you can tell us, we now know what a legal due diligence is, how it happens, what the issues are that could come out of that, the things we're looking at, how you mitigate. So that none of that happens, how can you best prepare yourself for a due diligence? I mean, I know likely there's always at least one issue, right? If you look hard enough, you'll probably find something. But even if there are things that are issues in your business, how can you best prepare your business for a legal due diligence so that you're as well prepared as possible? You're not going to incur these sort of deductions on the purchase price because of some issue that we didn't know. You're not going to get all these crazy indemnities and warranties that you need to provide. How do you go about preparing your business?
So I would say some of the preparatory measures that we're going to discuss here do not necessarily have to apply for purposes of a due diligence that is due or pending.
Okay.
Some of these measures, exactly. Some of these measures would be best practice, whether a due diligence is coming up or one is not coming up. So one of them is one of the ways in which to prepare for due diligence, but which is also good practice, is ensure that you're organizing your legal documents properly.
Yep.
Organizing, and in terms of indexing, you know where this document is, where you know what the status of that particular document is. This helps you in the part of a due diligence, but equally helps you if you're not even undertaking a due diligence in terms of understanding what risks could be there. Because if your documents are all over, you wouldn't even know when a contract has lapsed. You wouldn't even know when one was signed and not completely signed.
Yeah.
You know, one party signed, the other one not signed. And then when it's called upon, you're like, this guy never really signed. Or somebody sues you and you're like, we have a contract, and you realize you're the only guy who signed it. So there was never a contract in place actually. So you need to organize your legal documents properly. The second one in terms of preparing for due diligence is, and which is also best practice, you know, is to centralize your information. But let's look at it for due diligence purposes for this conversation. So, you know, try to have all your documentation and information. And this is should be helpful to startups that are perhaps, or businesses that are going through a due diligence process. Make sure your businesses, the information that is required is in a central place or can be accessed in a central manner. You don't want to be, you know, this particular information is required. You're like, go to the finance registry, then go to the company secretary for this, then go and talk to our, you know, maybe our engineer. You want to sort of centralize it because it makes you're able to track what information you have and what you don't have, and maybe make the due diligence exercise much better. So another one is to conduct an internal legal audit. We mentioned in the episode 11 that you could do periodic reviews of your business. But if you're preparing for due diligence, you can sort of conduct a preparatory internal review to identify and address some of the legal issues that could arise. For example, you could just do a quick check of whether actually you filed your annual returns in a timely manner. You could check your structure. A lot of, especially older businesses, tend to have a couple of dormant entities within the structure. You know, some of them even have running contracts, but guys do not remember who entered a contract with which entity. So you want to review the structure and establish what entities you know, are there, and just do a complete sort of a small internal legal audit of your affairs.
Okay.
The other one, of course, is just ensure legal compliance. And by legal compliance, you're talking especially around regulations. Being compliant with the relevant laws and regulations that apply to the business. Ensure that your permits are up to date, your licenses, and any other compliance documents. The better way to do is to have a checklist of the licenses and permits that are required for your business, and
when they're gonna come due or expire.
The other one is, of course, intellectual property management. Just go through your intellectual property. You could start by, what do you do that requires intellectual property? What intellectual property do you use, including copyrights? Basically, just identify what this look like. And then once you've identified, then identify whether you own them or you use them under a license or an assignment or whatever kind of structure you have. And then identify if any of them has lapsed. Because actually, even registration of, some IP is not in perpetuity. You need to ensure that they don't lapse and you don't lose your right to that particular intellectual property. So you need to keep a track of that. Then there is, of course, employment practices. Just ensure that the employment contracts are up to date. You're complying with labor laws. If you're required to have a HR policy, it's in place and it complies with the law. You're required to have a sexual harassment policy. It's in place and it complies with the law. If there is any negotiated collective bargaining agreement, what are the obligations? Have you, what are the risks relating to this collective bargaining agreement? What are the exposures you have as a business? Just ensure that you perhaps identify all that and put and just try to to note whether they are in order and whether there are any gaps. It's important to do clear communication with the parties that are undertaking the due diligence, and especially if you're having conversations with potential investors. It's good to be honest, to have clear conversation. I know some people may be uncomfortable, but because sometimes you fear the deal may fall through. You really want this deal, but you're fearing, if I tell them I haven't filed my tax returns for 2 years, I might be in serious problems. Maybe, but just be transparent, because all these things, like we have already discussed, mitigation measures.
Yeah.
A lot of them can be mitigated in a particular way or the other, in a way that does not risk the deal from falling through.
Yeah, especially if they're identified early enough.
Exactly, early enough. Some of them can be done pre-signing. Others could be conditions precedent, which means as soon as you start satisfy them, the deal closes.
Yeah.
But it's different now when you hide them, and then when parties have already signed, the things just start popping and showing up.
Yeah.
That of course erodes a lot of trust. Prepare your team. Now, this is of course in a logistical perspective. Due diligences require a lot of work, especially in collecting information, indexing that information, and providing it as required in the checklist.
Yeah.
So ensure that you have prepared your team. Guys should be ready for a bit of long hours sometimes. And even when the parties undertaking the DD, of course, prepare the team. It helps to be objective. That's another element for purposes of being ready for the DD. Try put yourself in the shoes of the one who will be the prospective buyer.
Yeah.
Just try to see how they would see some issues and how they would treat them. Anticipate situations, and makes it easier for you to be ready for a negotiation.
Yeah.
If they're supposed to be CPs, you could already just tell them that I'm working on this and I expect that we'll have resolved them by signing. So we don't need to have this as a CP. And I mean, if that is cleared, you don't need to have it as a CP. So just try to see objectivity. There are a couple of others, but I don't want to rehash this. I'll just mention just some of them. Is it's good practice to ensure that you always document anything for the business. We have seen situations when you start to review a business and the shareholders are telling you that the business owes us money. We gave it a loan. Then you ask them to provide you with a loan agreement. They're like, no, we just provided money.
Yeah. There's
no record. And then you're starting to get WhatsApp messages, screenshots of a message, guys said, send money, So it's good habit to just document everything, especially relating to the business. Yeah. And this is important even when you're founders, because there's sometimes guys basically forget to run their business as a business.
Yeah.
They keep running it as a, just keep it going, but they're not really documenting. It really doesn't help much when there's a DD. Ensure all signatures are in place. I think I mentioned this on the document management. Sometimes you have a document that is signed by one party and was never signed by the other one, or if they were signed by the other party, you never got the signed pages.
Yeah,
so things
and
are
dated
all over.
As well. Signed and dated,
exactly. So that's important to ensure. Proof of ownership is also another one that is important. And this is for whatever asset that you're selling or whatever asset that forms part of the business, ensure that you have proof of ownership. This could be share certificates for shares that you own. It could be logbooks for vehicles you own. Any, sort of title deeds for land and property. And then corporate structure, ensure that is clear and cleaned up ahead of the DD, especially if it's an acquisition or an investment transaction. You don't want to have one shareholding or 20 shares owned by a random guy who you haven't talked in 20 years, and it's all over the place, because this affects how you will draft the documents.
Yeah.
You don't want to start involving a party who cannot even be found to sign the documents, and just ensure that is done. And the final one, which would be an important one, to help in the process of the DD, it is essential to retain a trusted advisor, either to help you put your house in order or even advise you through the legal due diligence process in terms of, especially for example, and we have already discussed this, which is a case of what information can you provide or should you provide? Because sometimes we have situations where a competitor may seek to acquire you, and mostly if they are from another country. Let's say, for example, it's a Ugandan company that proposes to acquire a Kenyan company that does the same business.
Yeah.
Of course, your guard is low. So you provide information, go through the DD process. Then midway, the company, the Ugandan company, it's an example, says we are done. We don't want to do the deal. We think we are not happy. Then you're disappointed. Then the next thing is you see a subsidiary of the Ugandan company has now been set up in Kenya with almost a similar business model. You know, they dug up the information. They're like, this is the way this guy operates. Instead of acquiring them, let's just launch, you know. So you also need to know how to balance the confidentiality level with also the commerciality. I mean, ability of the transaction to go through. You know, you're not putting hurdles, but at the same time, everybody's being sensible. So that you don't end up with situations that are not good. And a trusted advisor, of course, can help you, whether they are a legal advisor, especially a legal advisor or a tax advisor, can help you, get some of things out of the way. If it's returns, you just file them and move on. If it's tax arrears, you clear them and move on. So that's just about it. I think that covers our discussion today around the legal due diligence. I'm sure it's not comprehensive, but we have tried to do it justice within the short time we have. But some of the items we have discussed, we will be able to. They will definitely come up in a future episode. I think especially warranties and indemnities. That's one thing I think we will discuss. In a future episode. And
so, if there are things that you as viewers or listeners heard or saw that you wanted more on, please just let us know in the comments and we will do more of that in a future episode.
Sure. Yeah, so Adrian, it's your turn to let us know about the, give us some wisdom from the course. So
the thing comes on the screen. Wisdom from the course. This today's wisdom from the course is more lighthearted. It's just really about having fun. Not forgetting to have fun. And I talked about this last season where I talked about trying to teach folks how to play golf and telling them relax, just have fun, don't think about your shot and all of this, and how I always forget to have fun. So the last time you and I played, we have this thing where someone goes first, tees off, and then maybe it goes all the way right, like out of bounds. And then the second person goes and same result. It also goes all the way right out of bounds. And we're like, oh, you showed me the way. You showed me the wrong way, really. And it's funny, every time we say that, we then start singing that. Show me the way I can go.
Okay.
So, funny enough, actually, funny thing on that song, actually, I had to look it up because I was like, what is the name of this song? Because I know we all know it, we always sing it, but I never know what the lyrics are. Apparently, the lyrics are, take me by the hand, show me the way I can go. But I always hear Chibadie.
Even me, I hear Chibadie.
So I don't know. Anyway, for me, I know it as Chibadie. So anyway, I started like humming that song as I was going through the course. Like the first 9 holes, I think, this song was stuck in my head. And the funny thing is, I said, you know what? Let me actually think about this song and just relax. Before I took every single shot, I had this song going through my head and I just kept humming it. And for some reason, it helped me relax and not think about all the, usually I have like 50 swing thoughts before I take a swing. I'm like, is my left arm straight? Am I doing this? Am I, So I try to erase all of that and just think about this song and just have fun, something more light. And I started having way more fun. I was getting much better shots. I mean, it was still wasn't the best golfing outing ever, but it was pretty decent. And I think more importantly is I relaxed and I ended up having fun, right? So it's a random thing, but it just reminded me of the importance of having fun, and that if you're not having fun, maybe it's not worth doing, right? So just don't forget to have fun, and it'll do you a world of good if you do. It might improve your performance in whatever it is that you're doing. It may remind you why you're doing it, what it is that you're doing, but you're more likely to also keep doing what you're doing if you're having fun. Agreed. So don't forget to have fun, guys. Whatever it is that you're doing, whatever it is you're working on, whatever it is that you're endeavoring to do, just have fun and make sure that you're having fun while you're doing it.
Oh, absolutely agree.
That's my wisdom from the course.
Oh, that's a good one. Especially because golf has so much pressure.
Yeah.
It's possible to get caught up with the pressure that's so much that you actually never enjoy around.
Yeah.
All the time you're tensed. It's like sitting an exam, like you're under so much pressure that you forget to enjoy yourself.
Yeah.
Wow.
So for me, I'm keeping that song. It's now going to be my golf song. Every time I show up to the golf course, I'm going to be humming, "Show me the way I can go." Anyway, you want to give us something interesting you learned in the week?
I was going through, it was on my Instagram. So there's a gentleman called Stephen Bartlett. He's a podcaster.
Yeah, sounds very familiar.
Yeah, he's a podcaster, and I like his podcast actually. So he had posted a quote that says, "Embarrassment is a cost of entry. If you're not willing to look like a foolish beginner, you'll never become a graceful master." And it's a quote by Ed Latmore. I think he's a boxer or something.
Okay.
So, and I thought about it, and I was like, it's very profound because there are many times maybe you may feel like you don't want to do something because you'll be embarrassed. You've never done it before. You look like a rookie, and you're not ready to look like a rookie in your big age. And then what that does for you is that it denies you opportunities to ever be good or become successful at something. Because anything that you're beginning, you're not going to be an expert in it.
Yeah.
Whatever you're beginning. I mean, when we began our podcast, we knew very little about it. But I think we have grown. We have learned a couple of things. I remember the first day I showed up at a golf course, with my nice bag. I've invested in a golf club. In the first few games, I used to feel like an imposter. Like, I used to feel like guys are going to see through my BS. Guys are going to see through, the fact that I'm such a rookie. My balls keep flying all over. And I think that's the thing. Like, you have to allow yourself to be embarrassed because that's a cost of entry.
Yeah, it's a price of admission.
Yeah, exactly. And so long as you keep showing up every time, you will, in no time, you'll move from being that, beginner to somebody who is more graceful, more confident with that. And maybe it's also a call to those people who have been doing things longer to show more grace to guys who are beginning. Yeah, because already they're dealing with enough embarrassment of that they don't know. So that has been my lesson for the week. What has been your lesson for the week?
It's funny, I actually saw something very similar to that this morning. George Ndirangu on one of his videos talking about, I guess he's like life mantra is, life is a journey, pack light. So he's like, don't stress it, don't be overwhelmed, like, enjoy things. We're only here for so long. So don't be afraid to go to that dancing class because people are going to see you dancing and you don't know how to dance. It's like, so now when will you learn to dance? Just do it, right?
Just do it.
It's the price of admission. So great one. Thank you. My interesting of the week, I was on LinkedIn. I saw a video posted by Larry Mado, a journalist, big Kenyan journalist. He was at the CEO forum in Kigali, and he was interviewing Dangote and a few other folks. It's also surprising that Dangote is just now coming up on this podcast for the first time. Wealthiest African guy, but anyway, I'm sure he'll feature more. So you know what I'm saying. So he basically, Dangote says he's asked about the whole visa issue and the difficulty in traveling within Africa, and he's like, "Listen, it's crazy to me that I need 35 visas to travel within the continent. Like he needs 35 visas as this huge investor, huge." Personality within the continent to get around. And yet across from him at the time was the chairman of Total Energies, who's a French person named Patrick Pouyan. And he, with his French passport, doesn't require a visa for most places to travel on the continent. So it's so telling that we can't travel within our own region, but other people can come in and out as they choose. All these artificial barriers that we've set. And so anyway, the hope being that the African continental free trade area that's coming there, Africa, that those limitations will fall away. But not even just the visa travel, it's also the difficulty in traveling within the continent. I just literally this morning, I had to check to make sure that this is still true. A round trip flight from Nairobi to Dubai will cost you less than a round trip flight from Nairobi to Zimbabwe. Which is like, it's obvious to us, but it's like, what? That's so absurd, right? It's so...
Well, I don't think it's usually absurd per se. A lot can be said about
Okay.
that. But I think sometimes it falls to the question of frequency.
Okay.
How many full flights can you do to Zimbabwe, between Zimbabwe and Kenya?
Okay.
Um,
But see, you'll take it that step. But I'll then ask you why.
Yeah.
Why are so few people traveling from Kenya
because
to
I
Zimbabwe?
think usually, let's not even look at it from the flight perspective.
Okay.
Let's start with, we are not, number one, doing enough trade with each other.
Mm-hmm.
Number two, our infrastructure interconnectivity is terrible.
Mm-hmm.
Doing a
Huge
road trip,
fragmentation.
maybe if you decide to drive through all the way to Nigeria, you go to places that are actually dead. There is no road in between. The interconnectivity is bad. So
Yeah.
basically, where our mobility is usually not as good.
Mm.
So you find that a flight that is perhaps flying from Nairobi to Zimbabwe probably will not be full, will not be full capacity.
Mm.
And what that means is that the cost of that flight will be distributed among the few of you that are flying.
True.
So it will always be like the few that are flying have chartered the plane.
That's true.
So that's why the ticket perhaps may be.
Yeah, I mean, even if we were to take another example, like Nairobi to Kampala,
Yeah.
there's a lot of people that make that route.
Yeah.
That route is way more expensive than it should be. So it's like even within our region, the flights that we do have for the places, even those that are more widely traveled or more frequently
Exactly.
traveled, even if you were to discount for the fact that not as many people travel XYZ routes,
Mm.
there's still a higher price per
Yeah.
the premium for traveling within the continent is higher than it is traveling outside.
I'm
the
telling
continent.
you, it's totally absurd. But I think those things need to be addressed. Actually, I remember a time we were traveling to Dar es Salaam, and the flights from Nairobi to Dar es Salaam was so expensive that we decided to do a 3-hour road trip to
Okay.
Arusha, and Arusha just across the border,
Yeah.
and fly from Arusha to Dar. And it was like flying, like in terms of cost, man, it was just something else. From Arusha to Dar, which is far,
Yeah.
the cost ticket was just probably a quarter of what we would have paid if we flew right from Nairobi to Dar es Salaam. And just and then we only
Yeah.
suffered a 3-hour trip,
Yeah.
on the road. So
So
just
yeah,
don't know,
I mean, there's a lot of potential, still a lot of issues that we need to work through as a continent.
yeah,
But
that's true.
hopefully, as we continue to progress, hopefully more conversations like this,
Yeah.
specifically the free trade area, I think will continue to open up borders
Yes.
and make things like this easier. And hopefully, also those prices will drop or reduce, and then we can travel more freely and see one another across the continent.
Indeed.
Yeah, maybe we'll take the Full Scale podcast on the road. Yeah.
We should. We should. Okay.
Anyway, that's us for the week, I think. So you want to close this out?
Yeah, wonderful. So thank you so much, guys, for joining us for episode 12, which is a continuation of episode 11, where we were discussing due diligence reviews generally. In this particular episode, we have just looked into legal due diligence. And we have, first of all, discussed what's a legal due diligence. We've discussed what are the particular items, areas you expect to see in a legal due diligence. How are you expected to report, and what are the outcomes, and how do you prepare for a due diligence? Thank you also for listening in to our lessons for the interesting things for this week. And wisdom from the course from Adrian. Thank you very much for that. Yeah, so we hope you enjoy and learn a bit from the content. And when you interact with it, please let us know your thoughts and feedback once you have interacted with your content. We encourage you to subscribe, especially if you're watching us on YouTube. Please subscribe. It does help our channel and our podcast a lot more than you would think it does. So we would be grateful if you can subscribe and share with a friend or somebody you know would benefit from our podcast. Let us know your views as well, as I've mentioned. We will also have a weekly challenge, as we mentioned in episode 11. Please be on the lookout for the same. We'll have something exciting, more of engaging you to try and have some of the key terms, in the startup ecosystem settle and rest well with you, so that whenever we say cap table, we are not confusing you, or we say something like IP or runway, we don't confuse our audience. So we would want you to be engaged with us and learn some more. So thank you very much, and see you next week.
Bye.
Goodbye.